area patent attorney Mark Trenner. Mark has been practicing as a patent attorney for almost 14 years and the past 9 years at Trenner Law Firm. While his practice focuses primarily on helping small businesses protect their inventions with patents, Trenner Law Firm also assists clients in building out all aspects of their intellectual property portfolio, including copyrights, trademarks, and trade secrets. So recently there was an article in the Kenosha News in Wisconsin where it was titled, "Where Do I Go with My Bright Ideas?" And it refers to a local inventors and entrepreneurs club in Wisconsin, Mark. And I'd really like to get your take on this. What is your take?
Thanks, Dan. Yeah, I saw that article, and I just want to say for our viewers that Colorado, if you're in Colorado, we have an inventor club here too. I think it's the Rocky Mountain Inventors Club, and most regions of the U.S. do. So wherever you're at, if you're interested, look them up and see if there's one near you that you can go, maybe join or attend a meeting. These clubs can really be a good place to meet other inventors, find out about local businesses that might be offering services specifically for inventors. For example, prototyping, marketing, maybe even some help with getting some funding for your invention. You just really want to be careful not to talk about your invention when you go to these, or really if you go to any type of open meeting, you want to be real careful not to talk about your invention out in public.
Why is that? Don't you have a year from any public disclosure to file a patent application?
Well, that's really a good point, Dan. I'm glad you brought it up. The U.S. patent law used to afford inventors 1 year, just like you said, from any public disclosure or public use, sale, or offer for sale of their invention, or even publication of the invention, in which they had that 1 year period to file a patent application without losing any rights.
So why is there such caution about discussing your invention now?
Well, the patent law just recently changed here in the United States. The new patent law, known as the America Invents Act, or the AIA, it really took effect in a couple different stages, with many of the important provisions that we're referencing right now taking effect just here recently in March 2013. So while the law probably still needs to be clarified by the courts, and that's going to take time for it to work its way through the court and get some clarification on what exactly the law means and how it impacts inventors, it does appear at first glance at least that at least some of these grace periods that we were talking about, the 1 year period that you mentioned, might not be available any longer, or it might be restricted or modified.
So what are you advising your clients under the new patent law, this America Invents Act?
Well, Dan, I've always advised my clients not to publicly disclose, publicly use, publish, or sell their invention prior to filing a patent application. And that's mostly had to do in the past with foreign filing. While many inventors may initially think that all they need to do is file in the United States, there's times when it makes good business sense to file a patent application for your invention outside of the U.S.
So even under the old patent law, you advise this way?
That's right, because most foreign countries have a stricter standard, or had a stricter standard, than the U.S. patent law with those grace periods, and they required inventors to file a patent application for their invention prior to any public disclosure of their invention.
Gotcha. So it's always been good practice to keep your invention confidential until your patent's been filed.
That's right. It has, especially if you were considering foreign filing, and now especially given the new patent laws in the United States as well. So you'll want to be sure you talk to a patent attorney about that and find out how the changes might impact. And before you talk to a patent attorney, at least make sure that you're keeping your invention confidential.
Okay, so back to the article, I see they also discuss the cost of applying for a patent, and that many inventors are foregoing the patent process and just taking their product to market.
That's right, I saw that in the article too. And the article also points out that under the old patent law, there really wasn't necessarily a need or a hurry to get to the patent office to file, and so that may have been a good strategy. But the America Invents Act, this new patent law we're talking about, also introduced what's called the first to file provision here in the United States.
So what's first to file?
Well, so let me just go back a minute. The patent law used to be a first to invent system in the United States. In other words, before the America Invents Act, the new patent law we're talking about, if two people filed a patent application for the same invention, the U.S. Patent Office would grant that patent to the inventor that could prove they invented the invention first. Like the article says, though, inventors could take their time under the old patent law to explore marketing opportunities, and they'd still be protected with those grace periods.
And how did the America Invents Act change all of that?
Well, the America Invents Act changed that significantly. The article points this out. They say that the AIA, or the America Invents Act, has actually changed under the first to file system to a race to the patent office, where by race I mean whoever files their patent office first, they're going to be the one that gets awarded the patent, regardless of who may have invented it first.
So why did the AIA make this change?
Well, the article talks about this too, and this part of the law was really intended to bring the United States into line with the patent practices of most of the rest of the world.
It doesn't seem like necessarily a good change, though, does it?
It doesn't, and that's what a lot of people are saying. It kind of depends on your perspective. But this article also mentions that the law seems to disadvantage the individual inventor and small businesses who might not have a patent attorney on staff that can file a patent application at the drop of the hat.
Thanks, Mark. It's about all the time we have for today. Really appreciate it. Just great information for any inventor or anyone looking concerning patent law. Be sure to visit Triner's Law Firm website at us-patentattorney.com or his blog at ipatentattorney.org. They're both full of really excellent, original, and very informative content, if you will. So thanks for your time today, Mark, and we'll see you soon.